Good afternoon or good morning. This is Mark Horoupian. Welcome to our webinar today, which is called When Litigation Turns to a Threat of Bankruptcy. I am Mark Horoupian. I'm a partner at Solmeyer Kupitz. We are a boutique firm in downtown Los Angeles, also with an office in Orange County. And the focus of our firm has been and continues to be bankruptcy and insolvency-related matters, restructurings both in and out of court, Chapter 7, Chapter 11 matters, and we also have a litigation department and a corporate department that largely does litigation and corporate transactional work that spawns out of bankruptcy matters. The firm has been around since Irving Solmeyer formed it more than 60 years ago, and I myself have been with the firm for about a third of its existence. Let's get started, and I hope that you find this webinar informative and helpful. Let's go over what we're going to cover in this webinar. First, we're going to talk about the steps that you can take in order to strengthen your negotiating position with a defendant that is threatening bankruptcy. We'll use a hypothetical that we'll talk about a little bit later in the next couple of slides to guide us through the presentation. We'll talk about the questions and documents and things that you should ask to see in order to assess the threat of bankruptcy and how real it is. And when you gather that information, how to use it in order to make a realistic assessment, not only of the bankruptcy threat, but your ability to collect on a judgment if you're fortunate enough to get one, and how to use that information to your advantage during your negotiations. Finally, we'll also talk about the steps that you can take if you don't reach a settlement and your defendant actually makes good on its threat and ends up in bankruptcy either before or after your judgment. Now, on that last bullet point, it'll really be a little bit on the conclusory side. We won't have time to get into all of the things that you can do if you're a litigant and you find yourself in a bankruptcy case. Frankly, that is probably will have enough information for several other webinars. For example, in our archives on our website, you can go back and look at previous webinars that were done. One of my colleagues, David Richardson, I'll give him a plug. He did a webinar on removing an action from either state or federal court to bankruptcy as an option that you have if a defendant files Chapter 11 or Chapter 7. And I encourage you to go listen to that if you're interested. But hopefully we can just give you some tips on some of the things that you should be looking at in the event that your target, your defendant target, ends up in bankruptcy. In coming up with this topic, I think that the target audience here is litigators and their advisors who handle contingency fee cases against individuals and small to middle market companies. And while the matter doesn't have to be a contingency fee case, it could be an hourly fee case for you. I find that contingency fee lawyers may be most interested in this because they really become a partner with their plaintiff client in an action, because you're putting out, as a contingency fee lawyer, you're putting out your time, your effort, and sometimes your actual money for advancing costs for your clients in the hope that you're at one day going to get paid. So I think this information would be particularly helpful to those types of practitioners in order to make informed decisions both at the get-go of the litigation and along the way. So some of the example of some of the matters that fall under the umbrella of who I think would be interested in this matter or in this webinar are personal injury cases that are not going to be covered by insurance. Having insurance there gives another dimension to your case and another dynamic to your case, because you're maybe not so concerned about the financial solvency of the defendant if you know that an insurance company is standing behind that defendant and is going to pay the judgment that you recover or the settlement that you negotiate for. So we're looking at personal injury type disputes that are not covered by insurance, business disputes, a very common area these days, wrongful termination, harassment, wage and hour type litigation, employment type litigation that's become much more prevalent. You're seeing high dollar recoveries against small to middle market companies that really can't afford to pay the judgment, and we'll talk about a little bit about that in the next slide. And basically any matter where payment of your eventual judgment is going to be by a defendant or defendants as opposed to an insurance carrier. When I came up with the idea for this webinar because of what we're seeing in the marketplace. For many years now, I've been asked, and my partners and colleagues have been asked to get involved in litigation, mostly on the part of defendants. And because of the reputation of our firm, we've been around for a while and we're known to be bankruptcy lawyers in the marketplace, litigants, defendants come to us and say, hey, would you pick up the phone or write a letter to plaintiff's counsel and tell them that you've been retained by the defendant and that you're going to file bankruptcy if litigation continues and a settlement is not made. I'm trying to bully the other side into capitulating to settlement demands on the threat of bankruptcy, which is the topic of this discussion, of this whole webinar. More recently, I think plaintiffs' counsels are recognizing the threat of bankruptcy. They're also recognizing that defendants sometimes throw around that word without really meaning it. So I've been asked more recently by plaintiffs' counsel to come in and advise them if that threat is being made to them. What are the chances of this actually happening? What should I be looking at, and what should I do? And so that's what really spawned the idea for this webinar. As I mentioned in the previous slide, we are seeing more and more bankruptcies by small and middle-sized companies being precipitated by adverse litigation. I recently wrote an article that, from my perspective and my partner's perspective, it seems to have taken over as the primary cause of Chapter 11 bankruptcies being filed at least in California. You know, through the history of the economy and the cycles, you see different triggers over time. And typically the prevalent trigger for a company entering into bankruptcy was problems with their lenders or underperformance of the company, foreclosures when the real estate market goes down, and things like that. But we haven't been seeing that lately. There's maybe because there's an abundance of money in the market, an abundance of money being lent when businesses are having problems. But if a company gets hit with a large judgment that it can't afford to pay, they end up in bankruptcy, and I think that's taken over as the primary cause, and a lot of it has to do with employment type litigation. Some recent examples of some well-known companies that have ended up in bankruptcy as a result of litigation. Roscoe's Chicken and Waffles. It's a LA standby. It filed bankruptcy under its parent company name East Coast Foods after it got hit with a $3.2 million employment-related judgment for wrongful termination and harassment. We'll see. It's currently pending in the Central District of California. We'll see what ends up happening with that institution. Next is Gawker Media. You may have heard that Gawker Media, which is responsible for a number of internet content websites out there, recently filed bankruptcy in New York after being hit with a $140 million judgment in favor of Mr. Hogan. It's not his real name, but they apparently aired some tapes of Mr. Hogan doing things he shouldn't have been doing, and they were hit with a $140 million judgment by a jury, and they promptly filed Chapter 11. And while it might be nice for Mr. Hogan to have a $140 million judgment, it will certainly remain to be seen what he ends up collecting on that judgment at the end of the day. While this one is not that current, it's a few years ago, it was one that I was involved with, so I have some insight in. Power Balance. Power Balance made the rubber bracelets with a hologram on them that were supposed to give you, enhance your power and your strength and your balance. And they filed bankruptcy after agreeing to settle a class action lawsuit for $50 million. The bankruptcy was filed within a month or so after they agreed to that settlement agreement. So let's go back and start our hypothetical here. A hypothetical is that you are counsel to a plaintiff in a wrongful termination suit against her former employer, Big Mike's Janitorial Service. You've completed discovery, and you believe that you've gotten great testimony from the company's president and owner, Big Mike. You've lined up a bunch of witnesses who will testify that your client was not treated fairly, was terminated wrongly, and based on all that evidence, you believe that your case is a slam dunk as far as liability goes. This is one that you're itching to take to trial, and you and your client are seeing big dollar signs. That is until you receive a call from the defense counsel who tells you that his client is broke. The counsel goes on to tell you that his client would really like to settle this, but Big Mike's is so financially strapped that it cannot afford to pay your client more than $25,000. He tells you that if you do not agree to this, then Big Mike's will file bankruptcy, and your client will be lucky to recover a few pennies on the dollar. Of course, you're offended at this offer, and you and your client are inclined to reject it as a matter of principle and gear up for trial. The point of this webinar is to tell you to slow down. Don't act so fast. If the threat of bankruptcy is realized, it is not uncommon, in fact I'd say it's more often than not, that unsecured creditors get pennies on the dollar or nothing at all. And let's take the Power Balance case as an example. Here was a company, Power Balance, that was enjoying a tremendous amount of apparent success. They were selling about $50 million a year worth of product. They had athletes all over the world wearing their product and endorsing them, including Kobe and Shaq and Drew Brees. They had their name on the side of the Sacramento Kings arena. It was renamed the Power Balance Arena. So from the appearance, they had a lot of money, and I'm sure that the lawyers that took on the class action against them were thrilled at their prospects for recovery. What happened, though, in the case is they entered into Chapter 11 after agreeing to settle for $50 million. They didn't have $50 million, and the value of their assets was had been hit very, very hard by the negative publicity. And at the end of the day, when their company went up for sale, nobody was willing to pay anything of significance for the assets. We ended up with a very small pool of money. The costs of the bankruptcy, the superior position of the secured lender, we'll talk about secured creditor positions in cases, and generally the lack of interest in the product led to a situation where the creditors in that case will receive about 1 cent on the dollar. And the recovery was so small, the prospects for recovery were so small that the plaintiffs in the class action and their lawyers did not even bother to pursue their claim in the case. So it happens more than not. If there are any bankruptcy lawyers on the webinar, I'm sure they'll all agree that in a Chapter 11 case, it's more the exception than the rule, where creditors get a significant recovery on the dollar, particularly unsecured creditors. What we're not telling you is to accept the threat of bankruptcy blindly and just agree and capitulate to a settlement. This webinar will hopefully arm you with the skills and questions that you can ask in order to make an informed decision with some valuable insight. While the focus of the webinar is what you're going to be doing in the hypothetical when you're ready to go to trial and you enter into settlement discussions, there are some things that you can do to maximize your leverage early in the case, even before you take it. And we say this from experience as Chapter 11 lawyers, where we take some significant steps to underwrite the taking of a Chapter 11 matter. We are, when we take on a case that a debtor is trying to restructure, we're very much like contingency fee lawyers. We like to say that we're contingency fee lawyers without the upside. We bill on an hourly basis, but at the end of the day, if the case is not successful and the case turns into a liquidation, we only get paid if there are sufficient assets out there to support a payment of our fees, and we take, in most part, we take after the secured creditors get paid. So we need to, in underwriting our cases, we need to do some research, and it's the same type of research that you can do if you are presented with a plaintiff who says, I have a great case against this company, Big Mike's. You can do some research into the ability of Big Mike's to respond to a judgment. And while you're not going to have the same access level to information that you would later when you have a defendant who is cooperating with you and providing you information because he's motivated to convince you to settle, he's not going to provide that information to you when you're underwriting your case, but there's public information available. There's public records. You can Google search people. You can look into public records to see what kind of real estate they own. You can do Dun & Bradstreet research on their reported income levels. Now, this information isn't the most accurate thing in the world. I'm not going to give you a perfect view of the financial wherewithal of the company, but it'll give you some ideas. And you may also want to consider hiring a private investigator who do things at a level that we can't. They have access to databases and things that you might not have access to readily. but they can provide a tremendous amount of information for a relatively low cost, and it may be worth your time to hire a private investigator early on in the case as you're underwriting your decision to take on this case, and become a partner with your client. The other thing that I can't stress enough is name the maximum amount of defendants that may be liable. Of course, you need a good faith basis to do so, but adding individuals and adding other potential defendants maximizes your settlement leverage, because you have more parties that are motivated to settle and contribute to a settlement fund because they need releases from your litigation. Again, of course, I'm not suggesting that you add people in who have no potential liability, but if there is a potential liability, add them as defendants from the get-go. For example, look to statutory basis for liability of individuals. For example, in employment litigations, matters for directors and officers can be liable under certain circumstances. Actions brought for unpaid wages under the federal statute, the FLSA, can be personally liable, as they're considered to be part of the employer. There's a case called Boucher v. Shaw in the Ninth Circuit that establishes that. Other examples are private attorney general actions, PAGA claims, which may carry personal liability. Add those kinds of causes of actions if you have them, and consider the impact that will have in bringing people to the settlement table. Likewise, consider adding an alter ego allegation in your complaint if you have a basis to do so. Sure, we're all familiar with it. Alter ego is a powerful tool. It's a difficult remedy, but to prove, but you can add in that alter ego allegation in your complaint, and you're from the start involving the principal in the litigation. And while you have the option of filing a motion to add the individual in after judgment, my suggestion is there's no reason to wait around to do that. It's just adding cost to your case, and it's eliminating having an additional party potentially on the hook during your settlement negotiations. So consider adding alter ego allegations from the start of your case. So let's go back to the point in our timeline that we were with our hypothetical. Big Mike's has made the threat that they're going to file bankruptcy, and now you've considered it. You go back to Big Mike's and you tell them that if you want your client to take the bankruptcy threat seriously, you'll need to see proof. You'll need to get some evidence from them, and if they don't want to cooperate and provide this evidence, you can't take that threat seriously. A lot of times we'll see that defendants will present, in response to such a request, will present a summary balance sheet or a profit and loss statement and ask you to take their word for it based on those two pieces of paper. Those two pieces of paper are not sufficient. There's too much that can be hidden without full analysis. It won't give you the full picture, and it really is not something that you can base an informed decision on. You'll need to see more. You will need to analyze the assets, liability, and income of the company. So where do you start? The easy point is, let's start with the assets, and let's start with the most obvious asset, real estate. Ask to see, to get a description of all of the real estate owned or leased by the defendant. If they do own real estate, My suggestion is don't rely on an appraisal that the defendant may provide to you. Get your own. It doesn't have to be a full appraisal. Just talk to a real estate professional and get at least a range, a realistic range of the value of the real estate. Again, not because I'm a cynic by nature, but just because of having done this for so many years, we know that the value of real estate comes into play in a lot of cases, a lot of bankruptcy cases, and we know that if someone wants to show that the value of an asset of real estate is low, if that suits their purposes, there'll be an appraisal that will tell you that it's low. If you want to show that it's high, there'll be an appraisal that will show it's high. My suggestion is go out and get your own, get a realistic view of what the real estate is worth. If they have leased property, look at the lease terms. Ask to see a copy of the lease. Is the lease under market? If it's an under market lease, it could be a valuable asset that wouldn't necessarily appear on a balance sheet, but would be something that you should consider in terms of a bankruptcy case or an eventual bankruptcy case. If it's above market, you want to see whether that lease is with a principal or owner of the debtor. A lot of times you'll have the owners of the company also own land and separately lease it to their business. If it's above market, it may be a way that the owners are siphoning money off from the company, and something that you need to know. So find out. It's also, obviously, if you find out that the owner, let's say in this case, Big Mike, is leasing a piece of land to Big Mike's janitorial, and that land has value, it may be something you should consider in terms of your leverage against the individual. Next, you look at personal property. Ask to get an accounts receivable aging report. Look at the historic collection rates, because this will give you an idea of the value of that of those receivables. And if you see any large old receivables on the books, ask some questions about it. Find out what they are and whether they have any value. Again, going back to the balance sheet, a summary balance sheet may not discount appropriately for collection rates, and you should do it yourself. We'll talk about discounting a little bit later. Ask to see what equipment and vehicles the company carries on its books. Tax returns are a nice tool there, because if a company owns equipment and vehicles, FF&E, it is typically carried on the tax returns, and you'll see how they're being depreciated. So ask to see tax returns. Like all of this information that we're asking, some of the things that the defendant may just refuse to provide you, but if you get it, great, because I think it could be a good roadmap. When you're looking at equipment and vehicles, look to see if there are any personal vehicles included in the company's assets. A company like Big Mike's, it's a janitorial service. If you see a Porsche or Mercedes on the list of vehicles, it's a pretty good sign that that they're providing compensation, an additional form of compensation to their owners by paying for their personal vehicles. Look at inventory. Again, inventory as well as other asset categories need to be discounted significantly when you get all this information, and we'll talk about discounting later again. Intellectual property. A lot of times intellectual property will not show up on a balance sheet, but may be a very valuable asset. Taking, for example, the Big Mike's, the Roscoe's Chicken and Waffles case. I don't know what's happening in the case. I'm not following it, but if that case ended up in a liquidation and the assets were being sold, someone might want to pay a lot of money for the name Roscoe's Chicken and Waffles. So ask some questions about intellectual property. You might find some valuable assets there. Finally, very important in small companies, do not forget to ask about any notes from shareholders. A lot of times, small and middle market companies disguise compensation to their shareholders by giving them loans to shareholder. Those are carried on the books as a loan. It's a way for the company to avoid paying employment taxes and for the shareholder to avoid paying income taxes. Now, a lot of times they never have any desire or intention to repay those loans, and they just carry them and continue to carry them. But if the company ends up in a bankruptcy, there will be efforts to collect on those notes, so they're valuable. It's valuable information to have. You need to ask about them. Next, we move to, now that you know what they have, you need to know what they owe. And let's start with, at the top, secured debts. You need to know what banks they owe money to, and you'd want to see the loan documents if they'll provide them to you. You need to make sure that the banks, typically if it's a large bank, Bank of America, Wells Fargo, someone institutional, they're going to do things correctly and get their liens perfected properly. But if they're showing you secured debt to someone you don't recognize, some institution you don't recognize, it's advisable for you to check, and it's easy to do, to check to make sure that they actually recorded a UCC1 or recorded their lien and are properly perfected. Obviously, the importance of knowing what the secured debt is that in a lot of cases, the value of the assets don't exceed the secured debt, and in a liquidation, you're going to take the pennies that are left over after the banks get paid. So you really need to know what those secured liabilities are. Also, you need to know when the loans were taken out and what the company did with the proceeds. A common ploy by small companies that are facing litigation is to go out and either take a loan or increase the borrowing under an available credit line in order to make their balance sheet look like there's nothing there for the litigants. You need to know and find out when the loans were taken out, what they did with it. Taxes. You need to find out whether the company is current with its income taxes, employment taxes, sales taxes, because again, like the secured claims, they are going to take prior to payment of unsecured claims, which is what you'll be in this case. Also, if you have a company where they owe employment taxes or sales taxes, that's a company that's typically not doing well because they're borrowing against those taxes and making a big mistake in my view. But it's a good indicator that that's a defendant that you should not count on getting a lot of money out of. Next, look at trade vendors. Try to determine, again, from an aging perspective, how old those trade is. If they're carrying a lot of old trade debt, particularly if they're carrying a lot of debt to lawyers and accountants, might be a sign that you should run, because lawyers and accountants typically don't let their bills get that old, and if you see a string of different law firms on the trade, it's a good sign that that company is circling the drain. Litigation claims. It's pretty easy for you guys to do a public record search for pending lawsuits and take a little bit of time to look in on your electronic dockets to see what those cases are about and what stage they're in, because you may not be the only one suing the company and looking to get paid from the company's assets. And again, this is sort of a hidden potential liability that wouldn't necessarily show up on a balance sheet. Finally, look for debts owed to insiders of the company. A lot of times on a balance sheet you'll see notes to affiliate or notes to shareholder, and while those debts may not aren't necessarily invalid, if the defendant is showing that on the balance sheet for the purpose of showing you that the company is financially strapped, take those liabilities with a grain of salt and discount them during your negotiations, and tell the defendant, we don't count those in our assessment of your client's financial condition, because debts to insiders, there's ways to avoid those claims or recharacterize those types of debts as equity. And in fact, my partner David Kupitz, going back to a plug for our other archived webinars, my partner David Kupitz did a full webinar and has written several articles on the process of recharacterizing debts to equity. Income and expenses. With respect to income and expenses, now you're looking at the profit and loss statement. Again, looking at a summary profit and loss statement is really almost worthless. What we're looking for is, why we need to look at the profit and loss statement is we need to see if this company is worth saving, and how hard the defendant and how motivated the defendant is going to be to try to save this company. And you need, so in order to really determine that, you need to see how much money they're spending and on what. In particular, we're going to look at how much money the insiders and the owners are taking out. Look at regular compensation, compensation to officers, loans, again, personal vehicle payments, dividends, anything that you see that is a vehicle for the principals getting money out is something that you should be looking at, because obviously that pretty much tells you the profitability of the company and how hard you can press these people in order to save their company. If they're running a company and taking no money out and they're putting money in out of their pockets, the threat that they're going to just go out of business and put the company in bankruptcy is more real than a situation where it's really providing them with a good living and a good way of life. Next, you're going to look and ask about potentially avoidable transfers. This, avoiding preferences and fraudulent transfers, again, probably subject of several webinars that can be done, and that can't be covered today, could be potentially the most valuable asset in a bankruptcy case, and really needs to be considered in any liquidation analysis that's worthwhile. And that's because avoidable transfers that come into the estate may not be subject, and generally are not subject, to the liens of secured creditors. So sometimes, and many times, in Chapter 11 and Chapter 7 cases, the only source of recovery for payment of unsecured claims is from recovering avoidable transfers. So it shouldn't come as a surprise to people that when companies are facing litigation, a common ploy is to take money out and transfer it either to themselves or to affiliates, relatives, or just other companies that they may have control of. So you're going to ask to see payments that were made to principals and insiders within the last 2 to 4 years. The bankruptcy statute allows you to go back and recover fraudulent transfers 4 years from the petition date. whereas the California statute actually gives you the potential to tie in payments or recover payments or transfers that are 7 years old. Now, I think it's unlikely that a defendant's counsel is going to agree to provide information that goes back that far, but ask for as much as you can get. Ask to see payments to creditors outside the ordinary course of business. You may want to just establish a sort of threshold. All payments made within the last 1 year of over $5,000 or something along those lines. And don't limit yourself to payments of cash. Look to find out if any real estate, stock in other entities, or equipment, etc., have been transferred. So what we're going to do with, now that we've gone through and got this information, all the information that you've recovered from the defendant, Big Mike's lawyers, what are we going to do with this? We are going to create a liquidation analysis. A liquidation analysis is really the benchmark in all bankruptcy cases, whether they're a Chapter 7 liquidation or a Chapter 11 reorganization. If we're in a Chapter 11 case, the liquidation analysis is the standard for the minimum recovery that the debtor will need to offer in a plan of reorganization. There are dozens of requirements for a plan to be confirmed, but one of them, and perhaps one of the central ones, is that the plan treat creditors fair and equitably. And the code, the bankruptcy code, states that in order for a plan to be fair and equitable, it needs to offer at least as much as a creditor would receive in a hypothetical Chapter 7 liquidation. And so in order to show that, the debtor needs to create in its disclosure statement a liquidation analysis, and which is what we're talking about today. It needs to take its assets. It needs to discount the assets for liquidation value, subtract secured claims, subtract projected administrative costs, and determine the prorated recovery for unsecured creditors. And if the plan offers less than the estimated recovery for unsecured creditors, it can't be confirmed. So it becomes the benchmark by which a plan is measured in a Chapter 11 case. Obviously, if it's a Chapter 7 case, that liquidation analysis gives you your estimate of what will be recovered on claims. Now, when we were talking before about asset values, when you perform your liquidation analysis, you need to take certain asset classes and discount them for liquidation value. I see that in cases where bankruptcy lawyers are preparing a liquidation analysis and they're doing it without the benefit of talking to a financial advisor, they're just really guessing based on experience what a certain asset class would get. It probably makes sense to have a financial advisor talk to you about, for example, inventory in a janitorial service. What's the industry standard for liquidation value of that? Or property, plant, and equipment, what's the industry standard for liquidation value? Obviously, there can be a great room for disagreement and discrepancy in that regard. So on the next slide, you'll see an example of a liquidation analysis for Big Mike's. And unfortunately, you can't follow along with a cursor, so I can't use it as a pointer, so just follow along with me if you will. If you look at current assets, you'll see cash and equivalents. And in Big Mike's case, it has $50,000 worth of cash. Our estimated recovery percentage, our discount, is 100% because cash is cash. And that leads you to having an estimated recovery amount of $50,000. Go down to accounts receivable. Big Mike's is carrying $3.3 million of accounts receivable, and we discounted it by 25%, and we estimate that we'll recover 75% on those, or $2.475 million. You'll see that we listed recoverable transfers. We think that there are $1 million worth of potentially recoverable transfers. We're going to discount that heavily to 33% because we're going to have to take on a whole new set of litigation expense and risk of collection there. So we're estimating a recovery of $330,000. In long-term assets, we discount the property, plant, and equipment pretty heavily, and we find here that there's no real estate net of mortgage, no equity in real estate that we can recover. So after considering that, we come up with a subtotal of net proceeds available for distribution of $8.23 million. From that, we're going to subtract out the secured debt. And Big Mike's has a term loan, it has a credit line, and it has a subordinated set of secured loans. We're convinced that those are all valid, and they're collectively owed over $5 million. When we subtract that out, we end up with another subtotal of $2.98 million that's available to pay administrative claims and costs. And so, well, what are those costs? The first one we take off the top is the Chapter 7 trustees' fees. Again, we're in a hypothetical Chapter 7, and a Chapter 7 trustee gets paid as a percentage of the monies that he distributes. So going back, he gets a percentage of the $8.23 million that he's going to distribute. Rough calculation, this one is not perfect here, but roughly they get about, their fee is statutory, it's roughly 3% of the distribution, so the trustee will get paid $250,000. This analysis assumes that both the Chapter 7 trustee fees, trustees' professional fees, accountants, lawyers, etc., as well as any Chapter 11 administrative fees total $400,000, so the total admin claims are $650,000. This analysis presumes that there are no taxes owed and that there are $12 million of unsecured claims. The subtotal after you subtract out the administrative claims is $2.33 million. Divided into the $12 million gives you your percentage recovery of 19.4 cents on the dollar. That's what we're estimating an unsecured creditor, including your client, would receive in a hypothetical liquidation of Big Mike's. So now you know that, you're armed with this information, you know your downside risk if you push your defendant too hard and it ends up in bankruptcy. Take that and factor into the equation the delay or the potential delay in getting paid. I'm sure it probably shouldn't come as a surprise to anyone, but you know, bankruptcy, it can take years, sometimes a year is a minimum, I would suggest, up to 2 to 3 years from the time that a bankruptcy case is filed to the time that you actually get a distribution. So consider that, factor that into your potential percentage recovery, and then combine this with the information, combine this information with any leverage you've gained by adding alter egos or individuals into your potential defendant pool, and that should establish your bottom line. And with that, I think you have a very strong negotiating position. At least you are very well informed and can advise your client and consider yourself from your perspective as a partner with your client as to what you should do, whether you should take Big Mike's offer, and how hard you should push. So, as I mentioned at the onset, the last bullet point of our outline was what happens, what should you do if you push too hard, you reject the offer, and then the defendant turns into a debtor. Makes good on his threat. Again, there are probably at least a couple of webinars that we can put together on this topic alone, but just give some helpful tips to you. File a proof of claim early in the case. Don't wait around. Filing a proof of claim early, even before a bar date is set, does a couple of things. One, it sends a message to the participants in the case, the debtor, secured creditor, and anybody else, other creditors in the case, that you're taking this matter seriously and you're not going away. It also, frankly, just eliminates the risk that you miss a deadline. Missing the deadline to file a proof of claim in a Chapter 11 case is pretty much fatal. You can try to get out of it by trying to get to say you didn't have notice or you were excusable neglect. But if you don't file a claim in a Chapter 11 case before the bar date, you're pretty much out of luck. In a Chapter 7 case, if you get notified of a bar date and you file your claim after the bar date is filed, you get subordinated to timely filed claims, which could mean you're out of luck. So the wiser practice, don't risk it. Just file your claim early. Get it on the docket. It doesn't have to be perfect. It just preserves your claim. You can always amend and add later. You can consider things like seeking relief from the automatic stay to proceed with your litigation. And that's a topic that can go on for quite some time, but it's something you should consider and maybe talk to a bankruptcy practitioner about whether you should seek relief from stay to keep going with your litigation or what your other alternatives are. You should understand that the automatic stay does not prevent you from going forward with your case against individuals and any other non-debtors. The stay simply does not extend to non-debtors. The debtor can ask to have the stay extended, but it's an uphill battle, and it's basically like seeking an injunction from the bankruptcy court. But I think a lot of practitioners and certainly some state court judges tend to think that if the main defendant files bankruptcy, then the entire action is stayed. That's simply not the case, and you should consider filing an appropriate motion at the state court level to have the court determine that the stay doesn't apply. Sometimes the state court judge will kick you back to the federal judge and ask the bankruptcy court to make that order. It shouldn't be too hard to get that accomplished. In a Chapter 11 case, a lot of times, most times, there will be a creditors committee formed. Consider participating on the creditors committee. It gives you a voice into a bankruptcy case. It gives you, the committee has the power to retain counsel and financial advisors that you are not going to be directly responsible for paying as a committee member. Those professionals get paid out of the bankruptcy estate. So there's potential that you're paying for it indirectly, but it gives you a powerful voice in a case, and you can monitor what's going on with the case to determine whether you want to put any more time into your litigation, and maybe whether you should be going after the other defendants as well. Use the information that you've received during the negotiations that we just talked about, obviously without violating any confidentiality agreements, to your advantage. Provide that information to the Chapter 7 trustee if this is a liquidation, or the committee if it's a reorganization. That information that you've gained about assets and liabilities may be very valuable. It also may differ from filings and declarations that the debtor is making in the bankruptcy case. So use that information to your advantage. Finally, if you find yourself in a Chapter 11 case and you're fortunate enough to receive a settlement offer early on in the case, really consider taking it, because from our experience, the longer a debtor remains in bankruptcy, typically the worse the chances are for a recovery for creditors. The value of the debtor's business typically doesn't grow while it's in Chapter 11. What does grow are the administrative costs and lawyers' fees and sometimes interest to the secured creditors, all the while your ice cube is melting. So if there's an ability to get paid early on in the case, really consider taking it. Just as a little war story, I was involved in a case where the debtor's assets were sold early on in the case, and there was a large pool created. And from that pool, the debtor had offered to settle with a class action plaintiff, and from my perspective, made a significant offer. The class action plaintiff and their counsel rejected the offer and decided to pursue their litigation. But what happened in the interim is that the taxing authorities came in and made a very large claim against the pool of assets. So even though the class action lawyer ended up getting a judgment, at the end of the day, the taxing authorities got paid first, and the remaining pool for unsecured creditors like his client was depleted significantly. And while the case is not over, his ultimate recovery is going to be significantly less than what was proposed to him. So if there's a position to, if there's an ability to get paid and settle out early in a case, consider taking it. That concludes the webinar. I hope that you found it helpful and informative. If you have any questions, you can email them to me directly, and on this last slide you see my handsome face and my email address. Thank you very much.